Now, to help us analyze developments in the Senzo Meyiwa murder trial, we're now joined by legal analyst Kabelo Seabi. Mr. Seabi, thank you so much for your time and for joining us this evening. Let's maybe start off by seeing what should we make of the accusations made by accused number 2 Ntanzi regarding the alleged assault by authorities.
Good evening, Katlego. The issues as they stand in the trial within a trial that the judge must decide are based on the fact of whether the accused made the confession freely and voluntarily. Now, in the trial within a trial, what the court is looking at is to look at the circumstances around the making of that confession. The state has presented various witnesses, the magistrate who took the confession, the police colonel who took the confession, people who did the escorts when the accused was taken for the taking of the confession, and the people who were present. Now, these various witnesses that the state has presented, all of them speak to the fact that there was no assault, there was no undue influence that was brought to bear on the accused. What the state now also wants to do is to corroborate the version of these witnesses who transported the accused by producing the car tracking log, where it will be shown that this is how the vehicle moved, thus directly disproving the version of the accused. And that is where the matter is moving to at this stage.
I mean, the defense has maintained that every time accused number 1 and 2 was booked out by the police, they experienced torture at the hands of the police. If there's any truth to any of these allegations, what impression does this create, especially for our policing system?
Look, the position in law is that a person who is arrested for any offense is not to be subjected to any assault or pressure in order to incriminate themselves. And if there is any suggestion that the police had resorted to these unacceptable methods in trying to gather evidence to support the case against an accused, the court will be duty bound to exclude that evidence and not to accept it. And that's why the court at this stage is seized with this trial within a trial. It's to check from the evidence as to whether is there any substance to the allegations that the accused were forced or assaulted in order to persuade them to make the confession statements.
So much focus has been put on the validity of this confession. From your experience and with the facts on hand and with the back and forth that we are seeing in the courts, do you think the truth will ever see the light of day with regards to these confessions?
Clearly, one must look at the evidence that is being led in the trial within a trial holistically. It will be very unfortunate to simply be moved by one piece of evidence. You must remember that the evidence that the state has presented, as I said earlier, you have the magistrate, her version is corroborated by the interpreter, and to some extent also the people that were present at the taking of the confession. So the state has built quite a formidable case about the fact that there was no assault. The evidence that emanated as well, that the accused was taken to a dentist and the dentist recorded that there are no injuries. This has been a setback as far as the defense is concerned. But having said that, one must still remember that the only evidence that has been presented this far is the evidence on behalf of the state. The accused is going to be given also an opportunity in the trial within a trial to put up their own evidence. And once all the evidence has been presented, the judge would have to consider the total evidence that has been led by both the state as well as the accused before making a ruling as to whether the confession will be admissible or not.
So with that said, what should we make of the U-turn made by the defense with regards to the abandoning of the application to oppose the state's car-tracker evidence?
Look, if the state is to present that AVL report, and the AVL report says the vehicle moved from the police station in Pretoria and went to Moroka police station, it did not deviate. Obviously, that would be a setback for the defense. And it is probably the reason why the defense now feels that the presentation of that AVL report is going to be a setback for their case. And they want to exclude it. Although initially they had indicated they don't want, or they will accept that evidence be led on it. Now they've changed tune, because clearly, if the contents of the report says that the vehicle did not deviate, that is a blow to the claims that the vehicle deviated and there was an assault when the vehicle deviated.
And obviously with Judge Ratamokwatleng saying that there are some persons who don't take this case seriously, are we seeing some delaying tactics perhaps from the defense in them trying to gather some evidence with regards to that car tracker evidence?
Look, to be fair to the legal representatives of the defense, one must always remember that the legal practitioner who's acting on behalf of an accused person works according to the instructions given by the accused person. And the legal practitioner is bound to follow the instructions of the client. So if the client has changed their mind, it might be that the advocate for accused number 1 and 2 was given this instruction to say we are no longer contesting the presentation of the AVL, and at a later stage there was a change of heart on behalf of the accused person, and the legal practitioner in terms of the rules of profession must execute the instructions of the accused person.
All right, thank you for those insights. That was legal analyst Mr. Kabelo Seabi speaking to us there about the trial within a trial. Thank you so much for your time this evening. Now, more of your leading stories in a moment. Do stay with us.